Your patent sucks because it doesn't name the correct inventors. Maybe. My name is Steve Hansen. I've been a practicing patent attorney for over 25 years. Not only do I write patents, but I tear apart other people's patents in litigation. If you like this content, please do me a favor and like, follow, and share. When you file a patent application, you are supposed to name the actual inventors, all of them, and only those who are actual inventors on the patent application. Who are actual inventors? They're the people who contributed to the conception of what is in at least one claim in the application. You're supposed to name all of them and not add anybody else. I have run into problems with clients who have a group with a manager and they feel like the manager should be named on all their patent applications. No, they should not. If they didn't contribute to what is claimed, you should not put them on there. A lot of times there's people involved in a project who do a lot of work for that project, and then a patent application is filed, and there's no sweat equity here. Just because the person did a lot of work, for example, in creating prototypes or something like that, does not qualify them as an inventor. Now, at the outset of the video, I said maybe. And the reason I said maybe is because the law has changed in terms of what the implications are for failing to name the correct inventors on a patent. Before 2012 and before the America Invents Act was enacted, there was a specific provision in the patent statute that allowed an accused infringer to invalidate a patent because it did not state the correct inventorship. That provision was removed in the America Invents Act. However, some attorneys, and I've seen it in some district court cases, have argued that another part of the patent statute, which is still in there, Section 101, does provide a basis for invalidating patents if they don't state the correct inventorship. The Federal Circuit has not yet ruled that that is the case, although I have seen some district court judges, at least in dicta, suggest that they think that might be the case. So, for now, the safest path is to still name the correct inventors and only the correct inventors on your patent application. Now, the law of inventorship is a bit murky and metaphysical to apply at times. So mistakes can happen, and ultimately there can be a decision in court where, it turns out the inventors aren't who you thought they could be. There is a provision to correct inventorship in court. Section 256 allows for judicial correction, and now it is far easier than it used to be to correct inventorship. You used to have to prove that any mistakes were made without deceptive intent. You don't even have to do that anymore. Basically, if there's a mistake and you ask for correction, it can be corrected, and they don't look behind why the inventorship was improper in the first place, so that can save you. But bottom line, for now, still try to name the correct inventors. I hope that helps to keep you out of trouble, and I hope to see you here soon.